Good morning, Mr. Robinson. I'd like to tell you about Peter and Jennifer Pates, a married couple in their 50s who wish to run a motel business. Peter has accounting knowledge, while Denise used to be an administrative assistant. They have no health issues or family or financial responsibilities. They managed to raise $100,000 in working capital, but still have some other savings. They plan to work full-time in the business and share equally in the management decisions. They have no plans to bring anyone else in the business and hope to run it for the next 5 to 10 years to make enough to live on and save for retirement. They plan to serve breakfast and invest in a vehicle to transport guests. In considering the various business models, a sole trader would not work, as one of them would not have any rights while sharing in the liabilities as a married spouse. A joint venture is also not suitable, as they both wish to perform similar roles in the business. The only real option is between a partnership and a company. The partnership is not a legal entity according to Solomon's case, while a company is. For example, the partnership will not be able to take out a loan or a lease which have to be done in the name of the Bates, nor own any assets, while a company can do so. In setting up the business, the formation of a partnership requires no formal paperwork but cannot exceed 20 members according to Section 115 of the Corporation Act. While it can be established by means of an exchange of promises, a deed showing the terms of the partnership is advisable. A review of Part 2 of the Partnership Act will determine which ones they wish to alter by consent according to Section 22 of the Act. On the other hand, there are more costs and formalities to incorporate. Ideally for the Bates, a small proprietary company limited by shares as defined in Section 45A of the Corporation Act would be a viable alternative. While designated share capital will need to be retained till the company is wound up, there is no minimum sum. Such a company must not contain more than 50 non-employee shareholders under Section 113 of the same Act. The Bates can both be equal shareholders and directors, and the secretary need not be appointed according to Section 204A. While they want to retain the existing name of the motel, this is separate to the name of the business. They can choose to trade under their own names in a partnership, but if they would like to have a separate name, they need to apply to the Australian Securities and Investment Corporation under the Business Names Registration Act. Registration of business is contained in Section 117 of the Corporation Act, and the firm has means to acquire a shelf company on their behalf. They may trade under the company number or decide on a name which must contain the words Proprietary Limited according to Section 148, subsection 2, and must not be in current use under Section 147. A constitution under Section 135 is not required, and replaceable rules found in Section 141 can be used and modified accordingly. There will be a small annual review fee to ASIC each year, who must be notified of any basic changes to the company, such as the issuing of shares, change in directors and addresses. With regards to daily operations, there is a lot of flexibility in running a partnership and no financial reporting is required. It does make good business practice to record all financial transactions, which may help to report in their reporting to the Australian Tax Office. In either case, a business number will need to be obtained. As a small proprietary company, under Section 2M of the Corporation Act, a financial statement need not be lodged with ASIC, but transactions be recorded such that a true and fair financial statement can be prepared if required. Under Section 250N, there is no need to call a general meeting, and resolutions can simply be passed by agreement under Section 249A. With regards to liabilities, partner bears equal unlimited liabilities for profits and losses and must indemnify each other for any liabilities incurred. Under Section 8 of the Partnership Act, any partner or anyone held out to be a partner under Section 17 can bind the business to a contract. Each is jointly liable in contract and jointly and severally liable in tort. under Section 15. While motel insurance and workmen compensation can help mitigate this liability, it still exists for any items not covered, such as a breach of contract or default on the loan. Bankruptcy of the business will result in bankruptcy of the Bates. In litigation, the Bates in a partnership will have to sue or be sued in their own personal capacity, while a company can bring or answer a legal action. On the other hand, while each director has actual and ostensible authority to bind a company according to Freeman and Lockyer and Buckhill's properties, and the company bears unlimited liability for the actions of its directors and employees, the liability of the Bates is limited to the unpaid value on their shares under Section 9 of the Corporation Act, unless a personal guarantee was given. Similarly, the credit of the company is unaffected by personal insolvency of the Bates. Any contracts entered into prior to the formation of the company will need to be ratified according to Section 131 of the Corporation Act in order to secure this protection. Also, as an employee of the company, the Bates are entitled to workmen's compensation claims to which they are not in a partnership. In liability among the participants, the Bates owe fiduciary duties to each other in a partnership as seen in Birchnell and Equity Trustees, as well as Chan and Zakaria. Under Section 31 of the Partnership Act, they must render true and accurate accounts to each other, and under Section 32 must not derive private profits. Similar fiduciary duties apply as promoters prior to the formation of a company following Tracy and Mandalay, and later as directors. Directors owe fiduciary duties not to each other, but to the company. The 5 main duties include acting in the interest of a company, using their powers for a proper purpose, with care and diligence, avoiding conflict of interest, and avoiding insolvent trading. These can be found in sections 180 to 184 of the Corporation Act and is owed in equity according to the cases of Braham Ford as well as Phipps and Bodman, and in tort according to the cases of Daniels and Anderson as well as Permanent Building Society and Wheeler. The main point to be emphasized here is the need to ensure that they have sufficient money in the company accounts to pay debts when they become due. No minimum share capital need to be maintained as long as they refrain from insolvent trading and do not contravene the various provisions in Section 588G of the Corporation Act, which would subject them to civil and criminal penalties by ASIC and make them personally liable to pay compensation to the company as long as they can prove one of the defenses under Section 588H. The test for insolvent trading is objective according to Metropolitan Fire Systems and Miller, and to whether the conduct was reasonable at that time without hindsight. They must keep abreast of the financial situation, and non-participation is not a defense unless due to illness or some other good reason, according to Deputy Commissioner of Taxation and Clark. With regards to remuneration, partners share in the net profits according to Cox and Hickman. All profits in a partnership must be distributed and taxed as personal income. The company, on the other hand, can remunerate the Bates in more diverse ways. It can retain profits, which may be taxed differently. It can distribute dividends, which carry tax credits, remunerate the Bates as directors under Section 202A, or as creditors if they give a loan to the company, or pay them as employees according to Lee and Lee Air Farming. With new participants, the partnership is dissolved and reformed, and alterations are required to existing titles and debts. This makes it more difficult to bring in new people or raise capital. In comparison, a company can issue shares or sell shares in order to raise needed funds or add people to the running of the business. Finally, in winding up the partnership, there's very little formality as the assets belong to the partners. If the business becomes insolvent, the Bates will also have to declare bankruptcy. With regards to a company, the company enjoys perpetual succession. In the event the Bates do not want to or become unable to continue in the business, sale and transfer of the lease, contents of the motel, insurance and loans can easily be done and make it more valuable compared to selling off individual items. Otherwise, the company will need to be deregistered with ASIC. The residual sum after paying off debts will be divided between the Bates. In the event the business becomes insolvent, the personal assets of the Bates will be protected. In summary, a partnership is easier to set up with little running costs or reporting requirements, but exposes the Bates to the potential risk of all their remaining assets. This may be a significant factor given their age and wish to retire comfortably in 5 to 10 years' time. With this in mind, I strongly recommend they form a small, unlimited proprietary company. They have the necessary skills to handle the administrating and accounting requirements. There is more protection from unlimited liability and less risk to their retirement savings. Furthermore, there is more value in a company which can be sold or transferred when they decide to exit the business.